MIAM, first of all, stands for Mediation, Information and Assessment Meeting. And it generally costs about £200 plus VAT, and it lasts an hour. And at Blanchard's Law, we tend to do these virtually because we find that it is more convenient for clients and they can stay in their own home and they don't have the travel inconvenience. This meeting is an opportunity for you to talk to me in confidence. It is private and confidential, it does not involve your partner, and I can talk to you about what mediation involves, and you can also talk to me about any concerns or worries that you have about mediation, and also what your hopes maybe are for mediation, and we can think about that together. The MIAM itself, which is sometimes actually called an intake session, but the MIAM itself is in three parts. The first part is me talking to you about what mediation involves and also what it is and what it isn't. The second part is me asking you some screening questions. It will be things like whether you trust your partner, whether there is a power imbalance and that sort of thing. The third part is really you asking me about sort of any questions that you have, and also telling me your fears and concerns about it, any special arrangements that you might need for a mediation to go ahead, like having a supporter there or in separate rooms, something like that. And also really maybe what your hopes are for mediation. The MIAM is actually an opportunity for you to get to know me, to talk to me in confidence, because actually it is private and confidential and your partner is not involved in this session. A similar session is offered to them. But it demystifies the process because you can see how I talk, how I approach things, and you can decide whether we work together. If actually we both decide together that mediation is not for you, then the MIAM or intake session is actually the end of your mediation journey, and I will actually sign the court form to say that you can go to court. But we very much hope that the MIAM or intake session is actually the start of your mediation journey, that I then have a similar session with your partner on a private and confidential basis, and then you both move forward to the joint meetings. Mediation in the family setting is where a couple voluntarily come together in front of a mediator to resolve the issues that they have arising out of their separation or their anticipated separation. So it is a way of resolving family disputes. But having said that, you don't necessarily have to have a dispute. Maybe you just want a safe space in which to be able to have difficult conversations with somebody who can facilitate the discussion. Unlike in commercial litigation or commercial mediation, it doesn't tend to happen on one day with lawyers present in other rooms or in the same room. It tends to be a series of 1 to 2 hour meetings where you do the work in between, but then at the end of it you should have a proposal that you can take to your lawyers. I'm a great advocate of mediation. I have been a family lawyer for many, many years, and I can very much see the benefits of mediation. So when you come to mediation, it's the same process that is used at court. It's just a different method of getting to the outcome. So you and your partner remain in control in that it's not lawyers deciding what the conversation should be, or a judge actually deciding what is right for you and your family. You both decide. But we ask for the same documents, we have the same conversations, we look at them, we take the same issues into account, and actually we use the same law. So I would hope that actually mediation gives you both back control and that you come out with, certainly in regards to children, a more sustainable outcome, that you both have the confidence to then flex in the future if you need to, as the needs of you and your family change, and that you both are able to go forward in a relationship as co-parents and are able to have a conversation. Because actually one of the great benefits of mediation is that you can explore ideas in mediation without fear of being held to them. It's all without prejudice. But actually you can retain a relationship maybe, or build on a relationship with a partner in a way that maybe court proceedings don't encourage. The obvious benefits are that it is quicker, it is cheaper, because often the hourly rate is the same for the couple as it would be for an individual, and it can take place over a number of months, maybe rather than a year to 18 months with court proceedings. And we can also think about things that maybe a court aren't interested in, like contents, how you share the ownership or care of a pet, and all of those things that are really important to your family, but actually the courts aren't really interested in. We always recommend that people have a solicitor when they come to mediation, and that's because really mediation takes place in the shadow of the courts. And what we mean by that is it's the same law of England and Wales that is applied in family mediation, and it's no sort of special law for mediation. It's exactly what your lawyers would advise you on. So it's really important that you know what that law is. And generally speaking, we like both people to have taken independent legal advice, both before they start mediation, maybe during it, and certainly at the end. And the reason we want both people to have taken legal advice is that often when people are discussing their issues in mediation, they discuss them on the basis of what is fair and what feels right to them. And that actually may bear no relation to what the law of England and Wales is. And I can give you information about what that law is, but I can't give you advice. So sometimes spending lots of time in mediation sessions talking about what feels right to you may actually prolong the mediation sessions and mean that it takes more time and costs you more money. So taking advice at the beginning about what's in your best interest is really a good thing to do. It's also good to touch base with your lawyer once there has been disclosure, because actually, so far as the financial documents are concerned, I can't give you information about the extent or validity of those documents and what questions you should raise. What I will do is check whether the requirements have been fulfilled, and then I will deal with exchanging them between you. So liaising with your solicitor on what questions you should raise and whether you need to see more documents is a really appropriate thing to do. And then finally, at the end, it's really important that you see a solicitor to make that proposal that you leave mediation with into a binding document. So when you leave mediation, all the discussions will have been on a without prejudice basis, and the mediation settlement document will be a proposal. It's called a Memorandum of Understanding, and it's just that. And then once you've had advice from your lawyer, then they will make it into a binding document, which you can lodge with the court. So that you don't have to accept the advice from the lawyer, but the important thing is that you've heard that advice, and that means that you've given informed consent to what is being proposed, and that therefore on that basis the court will make the proposal into a binding settlement, and you should end up with a consent order.